either potentially favorable or neutral or unfavorable, may change once we get into the details. Also, there are a number of issues where, like with the RARCs and CARCs that we'll talk about in a few minutes, where they've said that they're going to issue sub-regulatory guidance. So we don't even know what those rules look like yet. So there's going to be additional advocacy around that. There's been a lot of advocacy around it already, but clearly they've indicated an intent to move in that direction, which is, again, very favorable.
So what's interesting is, we've been doing this for a while, and what I found to be kind of fascinating was the advocacy efforts in and around this particular process. I mean, they have these OMB kind of listening sessions, which, for our listeners who haven't attended one of those, they're very formulaic in nature, whereby OMB sets up the phone call. You have to be registered as an attendee, but then they invite other federal departments that may have interest in hearing the comments available, and they introduce themselves and identify themselves, and then essentially they just turn it over to you, and they literally just listen. Like, they give you no feedback, whatsoever. It is a listening session, and it's all documented on the website as to who's requested these meetings and had the. So kudos to all the specialty societies that really jumped on board and really forced this issue and drew light to some of the issues that we'll talk about. This final rule has helped with, but there still remains a great deal that we need to go through. So it was just very interesting to me, and I don't know what your thoughts are. I mean, we're used to advocating for specific, standalone bills, or, in general, coming up in July, the proposed Medicare fee schedule. And it's just a different kind of avenues that we had to take and that we had to explore in this endeavor.
Yeah, and kudos to all the specialties that you mentioned, Mark, and groups such as Zotec and other folks in the community that advocated so strongly in favor of changes. And we provided data. That was, I think, key to several of the changes that were made and will be made, is to show them that we wanted to be players in the process and honest brokers about exactly what our physicians and our clients were experiencing. For those who question how much time and money we spend in advocacy, I would hold this rule up so far as Exhibit A as to why we do it. And our whole team knows it takes a tremendous amount of work, and you're coordinating through trade associations, specialty societies. You have a lot of voices at the table, and it's not easy to get everybody on the same page.
Sure. One of the biggest operational, I think, wins, you mentioned it earlier in the RARC and the CARC codes, making that a requirement. We're still waiting on more guidance and specificity on it. But, in all of these lawsuits that have been filed, the greatest complaint is that provider groups and physician groups are filing ineligible claims. And that is a problem. And we all know that that's a problem. So I'm thankful that they're forcing the hand here for the carriers, who are the ones that have that knowledge, to tell us if it's a state plan or if it's a ERISA plan, and which direction it needs to follow. But can you talk about how that's going to help that process and what has been mandated now in the rule?
Yeah, I mean, you touched on it, Mark. The plans are the sole source of all the information necessary to determine if a claim that we file on behalf of a client is subject to the California state process or the federal process. For those states that have state-specified laws, roughly 20 to 22, depending on how you count, have a state-specified law, and most have an IDR process. So the other thing that's not been well known or talked about much is there were RARC codes and CARC codes created by CMS, approved by CMS, before the IDR process even began in the spring of 2022, where they would designate clearly that this is a federal claim, or this is a state of California or a state of Florida claim or a state of Georgia claim. And those codes existed. Now, the plans were not required. CMS said, we highly recommend you use them, but we're not going to require them. So there was pushback from the plans over the use of those codes. So I think what's outstanding for us right now is asking for specific codes around situations that we don't have presently addressed in the rulemaking. For example, if you have a ERISA plan opt into a state law, which is allowed in 7 states, Georgia being one of them, if that ERISA plan opts into the state process, there should be a code for that. And that's one of the pieces of advocacy we're going to need to do. And it's through a group called the X12. And X12 is the governor of all things related to the 835 and the 837. And I think, we don't know this, but I suspect that CMS is going to defer to the X12 committee in terms of developments on those codes.
Yeah, and I think it's going to be evolving too, because, we've seen state laws like Indiana in particular who have added on additional kind of notification requirements to the facility, et cetera, et cetera. So I think as states kind of evolve, these refining of these codes will need to happen in order for us to know exactly what we need to do and what we need to comply with. So it is definitely important.
And a code, for example, for the initial payment, and a code for the requirement that a code for the, if the health plan loses and they have to make the final payment based on the IDR adjudication. Open negotiation is another area that I think, the more I've studied it now, is a big win for the physician and hospital community. And the reason I say that is, I think it's fair to say that many of the plans, certainly in the beginning, maybe less so now, but still, I would say a predominance of the plans do not engage in the open negotiation process. Congress believed there should be a 30-day process by which both sides should be required to come together and engage in discussion to try to see if they can settle short of filing a formal IDR. Unfortunately, there was no requirement that the plans do anything or respond to open negotiation. Now there is. So there's a requirement. It's 30 days. It's in the statute. Now the plans, both sides have to respond within 15 days. So the physician group makes their offer to settle. And now the health plan actually has to respond in writing and say why they're not accepting that offer, which is something that arguably you could use an IDR. If they come back and they say, we just don't accept your offer, then you're saying in IDR to the IDRE, the referee on the field, we're here in front of you because they wouldn't respond to us, or they gave no substantive response to our offer to settle. So I think perhaps the percentage of cases settling before IDR should go up. And that's a positive thing. I think that's what Congress wanted.
Yeah. And we've seen examples where if both sides are willing, it does not have to go through the IDR process. But, it was in the carriers were really using this as a talking point on the Hill that physician groups weren't willing to participate in that. And obviously we saw the exact opposite, and just wasn't the case. One huge win from this final rule is the administrative fee reduction. Without question, this is a huge win for the physician and healthcare organizations out there. In order to initiate the IDR process and start on that road and file a batch, you have to register it with CMS. And that fee to do so was $115 up until this final rule, which will now drop it down to $15. So that's quite a difference. I mean, if you think about it, it's a huge, huge reduction. That honestly, I wasn't anticipating it being that large of a drop, but it absolutely will remove a substantial barrier to participation, especially when you're talking like a radiology practice, right, where the batch sizes are so small that you're not going to be able to, you wouldn't have been able to keep up with that if it was $115 per initiation. So I think it's also meaningful for smaller and independent practices too. That will help them as well. But without question, this is the clearest win in the entire rule. I guess one question that I have, and it's maybe just a rhetorical question, but what will CMS do with the over $100 million that they've collected to date? I've seen some refund checks coming back, or
I have to give credit to several members within EDPMA who advocated within EDPMA and separately with CMS that these should be reduced. In the final rule, they said that as of January 31, 26, there were 5.1 million IDRs filed. If you apply the $115 for both sides fee to that. So you multiply 230 times 5.1 million, you get $1.173 billion. That's
So my
9
100
zeros.
million, that's a little off.
Little, your 100 million was based on the Q1, Q2
That's
public
true.
use file.
Not the increase in the, yeah.
You didn't know the 5.1 million number. I mean, that really blew me away. And by law, they're supposed to charge a fee that's necessary to run the program. I don't think anybody would maintain and argue that $1.17 billion was necessary to run the program. So kudos to them to reduce it. I agree. It's an absolute win. And particularly on the radiology side, where the per procedure, as you know better than I do, the per procedure reimbursement is so much lower than it is, say, for emergency medicine or anesthesia.
Let's talk a little bit about the batching and the cooling off updates. From my standpoint, I feel like this was a semi-win for the physician community. Still needs some room for improvement, but definitely moving the cooling period from 90 to 30 days is great. I know there was a request to have that be even lower, and to some extent even a day from that standpoint. But they did expand the batching rules. So what was it and what is it now?
Well, batching previously has been largely for non-radiology groups by CPT code. So for an emergency medicine group, it's a CPT 99285. For an anesthesia, it's a specific ASA code. Now they're moving. Now, radiology has had more expanded batching, body area and system. So a CT of the chest and abdomen, for example, would be potentially batched together. Now they're saying, and I haven't been through all the details yet, there's some specialty specific batching for radiology, a specific set of codes that can be batched together. And then also separately from that, if you have the same patient, the same or consecutive dates, or the same claim form, and this is something we've been arguing really from the beginning. For emergency medicine, you have a motor vehicle accident, patient has an evaluation and management service to see if they have internal injuries, but they also have a head laceration. There's no reason that the head lac shouldn't be able to be batched together with the evaluation and management code. It's one encounter, it's one claim, and it makes perfect sense that they be batched together. Previously, that wasn't allowed. You had to take the procedure separately, and that was a separate fee and a separate process. So batching is going to be, I think, better. We'll have to dig into radiology, but I think the preliminary indications are the changes in the radiology code set specifically are going to be favorable.
Yeah, and I know ACR was very helpful.
Yes.
In pushing that on the Hill as well. So that's great. The portal, let's talk about that. I mean, what improvements does this final rule bring out for the portal? We talked a little bit about it and the open negotiations, but are there other things that by forcing into the portal will help? I also know that there was at the beginning of all this years ago, different plans were forcing you to do it in different ways, and this will kind of make it just a centralized location, which is also very helpful.
I think there are two aspects of this. I think one, it shows the intent of CMS to move the portal into being the one source of truth, which is what it needs to be. So there isn't, as we lawyers like to call, ex parte communication. So you've got an email flying over here and an email flying over here, and the plan says, I never got your email, physician group. I never got your offer. I never got your initiation. It all happens inside the portal. And so I think that's where they're going with the gateway. They talk about the IDR gateway that's coming later this year. It'll be very interesting to see how they do it because, like, for example, in Texas, everything happens within the portal. All the negotiation happens in the portal. You submit your offers in the portal. The responses are all in the portal. Everything's in the portal. So there is no external, I never got your email or I didn't get, this attachment or whatever. It's all there for a single source of truth. I think that's where they're going with the gateway, but we have to wait and see.
So I've often been accused of being pessimistic. So what still hasn't been fixed is the topic now. And, with all these operational improvement, it still feels like the bigger issue is enforcement. And for those that don't know, CMS and CSIO has the ability to, monetarily enforce the NSA for physicians and hospitals, but they do not have it for the carriers. And that remains a huge issue. And of course, as we're experiencing here, winning the IDR process doesn't necessarily equate to getting the money in 30 days. That has been a major issue where, they're essentially trying to be fiduciaries and strangle financially these groups, even after an independent arbiter said you owe the money. So that needs to be, improved upon. But also, the financial and administrative burdens ultimately will affect patient access to care because practices can't, deliver emergency services or radiology services. They may, in fact, go and get bought by the hospital, or they may be bought by private equity, or they may move to some place that has favorable, commercial rates. So all of this adds up to that main factor, which is to continue to provide, access to care for patients. With that being said, what is the next goal? And you and I have been advocating for what's kind of called the Murphy bill, and there's a companion, Senate bill to that. But talk a little bit about that.
Yeah, you're right. The rule did not address the enforcement issues at all, and it didn't address them in the proposed rule either. So, I think it's fair to say that the agency is kind of tacitly acknowledging their limited, as you mentioned, their limited enforcement ability over the health plans. So we need HR 4710, the Murphy bill, S 2420, to give them the authority over the health plans, and that's civil monetary penalty authority. So that's a $10,000 per incident penalty that CMS can assess against the health plans for non-payment. They can do that today on physician groups and hospitals if they balance bill a patient that should not have been balance billed in violation of the law. So you're right. There has to be parity with respect to that. In addition, the Murphy bill would give treble damages and interest to the physician group of hospitals. Again, they're filing 90% of the cases. They're winning 90% of the cases. So, but actually that would also apply if a physician group lost the case and did not pay whatever was due back to the health plan. So the law is going to be equal in terms of the non-compliant party being assessed treble damages or interest. So yeah, that's where the enforcement piece is not in this rule. I know that's disappointing to many. I didn't really expect it, so I know we have to keep pushing on the Murphy bill.
Yeah, and as you and I know, when we've talked to lawmakers about this bill, I think that there was a little bit of a wait and see as to what the final rule would bring. So obviously now is the time to beef up that advocacy. So it's a Friday, and it's sunny here in Indiana. So I'm going to be optimistic and say that overall, this rule feels like some meaningful progress, especially on the operational side. There are still a lot of implementation questions that lie ahead, but several of these changes could make a real difference for physicians and practices navigating the IDR process every day.
Completely agree, Mark. We're going to count this as a win. And the more I dig into it, it looks better. There are still a number of open questions and areas where we're going to continue to do advocacy. So our job isn't done, but at least with respect to this particular quote unquote game, if you will, we can count that as a W. We move on to the next and look forward to working with the community to advocate. We mentioned the Murphy bill. Please text ZPNSA to 50457. That's ZPNSA to 50457 to take action, to ask your member of Congress. I used to call it 30-second advocacy, and my colleagues in advocacy corrected me. It's more like 10-second advocacy. So take 10 seconds to do that. And I think that's a wrap on the final rule.
Thank you for listening to Zotec Answers. We'll continue tracking these developments and what they mean for physicians, practices, and the future of healthcare reimbursement. If you have any topics you'd like us to cover, please email us at zotecanswers@zotecpartners.com. Until next time, stay informed and stay engaged with your lawmakers.